Okay, welcome everybody. I'm Mark Lemley. I am a professor at Stanford Law School and director of the program in Law Science and Technology. I am also a partner at the Dury-Tongri law firm, and I do both intellectual property work and increasingly scholarship on artificial intelligence. Let me briefly introduce our panelists, and then I want to hear a little bit from the audience about sort of background level of knowledge, interests, and that sort of thing. So to my left is Dr. Ryan Abbott, who is a professor at the University of Surrey in the UK at the law school, also a professor in the School of Medicine at UCLA, and chiropractor, acupuncturist, has a very has written quite a bit in intellectual property and AI, as well as other things like Should Robots Pay Taxes, and has a forthcoming book on the subject. Chris, you might have to bring your own chair. Maybe there's one over there. To my right is Lisa Ouellette, my colleague at the law school, who specializes in patent law and also innovation law policy more broadly. And finally, Jim Pooley, who is an attorney in practice here in Silicon Valley, and also the former deputy head of the World Intellectual Property Organization. So we got a bunch of things we're going to talk about, but this is going to be a conversation both among the four panelists, but also hopefully among the room at large. So it would help to know a little bit about background. How many people here are lawyers? How many people here are engineers? Okay, public policy, social science. Okay, so pretty good mix. So we are going to sort of do some, we're going to talk about a variety of intellectual property issues and doctrines, but we will not sort of presume a lot of knowledge. If we are slipping too far into legal jargon, stop us and say, I have no idea what you're talking about. And please please interrupt with questions as we start out. So I want to start out with patent law. The sort of fundamental, first fundamental question is AI patentable? And I think that raises the question, what do we mean by that? So Lisa, you want to lead us off?
Sure. So just as a kind of background for those of you who don't know anything about patent law, I think my view is that AI doesn't require a fundamental rethinking of patent law, that there are basic patent criteria that now we have to think exactly how these apply in the AI context, including which aspects of AI we're talking about. But the basic requirements for getting a patent are that the invention has to be new compared to everything that has happened before, and not just new, but non-obvious. So a leap from what has happened in the past, looking at all prior publications and things that were being used in the world. It also has to be what's called patentable subject matter. So that means that you can't get a patent on something like the abstract idea of using AI to categorize skin lesions, but you could get a patent perhaps on a particular algorithm for doing that. So we can't patent an abstract idea or a law of nature, but can patent more specific things. This is an area of law that's changing a lot right now, so patent lawyers are fighting on exactly what that rule means. And then you also have to disclose enough about your invention so that other people who are in this field are able to make and use the invention without undue experimentation. But that doesn't mean that you have to know how your invention works or give a specific recipe for doing it, or including giving the source code for an algorithm. So undue experimentation can be quite a bit of experimentation. Figuring out how these apply to AI can be challenging, and the US Patent and Trademark Office is wrestling with this right now. They put out a request for comments in August for a list of questions related to AI inventions, including asking about what are the different aspects of AI that could be patented. And so they listed some specific aspects like the structure of the database on which the AI will be trained and will act, the training of the algorithm on the data, the algorithm itself, the results of the AI invention through an automated process, the policies or weights to be applied to the data that affects the outcome of the results, But they also asked for other ideas about different aspects of AI that could be protected through patents. They're also interested in issues of inventorship, who owns these, that we'll get to later. The questions that actually interested me most that they asked, and that are things I've thought about in the broader aspect of my scholarship, are the questions related to disclosure, like what you have to disclose to get a patent on an AI invention. So they asked about whether the degree of unpredictability of certain AI systems and things like deep learning systems with hidden layers that evolved during the learning and training process changed the requirements for how much disclosure is necessary to get a patent in these areas. And I think that these disclosure problems are not that different from problems that the patent system has wrestled with before, including in contexts that might seem very different, like biotechnology, where in the 1970s there were a lot of biotech inventions involving new microorganisms and things where it wasn't clear that just a written disclosure would be enough to allow other people to make it, that you needed to have access to the materials in that context. And then the international patent system dealt with this by saying that you could get a patent by making a deposit of biological materials. And there was a treaty in 1977 that set out the requirements for a internationally recognized depository. These deposited materials have to be made available to the public once the patent issues, and it's not that expensive to deposit materials or to access them as a member of the public. The disclosure rules also changed in 1990 for patents on genetic sequences, where you have to, if you're getting a patent related to the nucleic acid or protein sequences, you had to disclose the sequence in a standardized electronic format to allow people to find that more easily.
So do you think we should deposit algorithms?
Yeah, so that's what I'm saying. Like, I think currently there's a consensus that these disclosure rules are not working as well in the software context as they are in the biochemical context, either in terms of limiting patent scope or in terms of conveying technical knowledge to people in those fields. A number of people have suggested that software patents should be required to disclose more, including disclosing the source code itself. I think it probably is a non-starter politically, but might be a good idea as a policy matter to require disclosure and perhaps deposit of the digital materials in a standardized depository the same way it is for biological ones.
But why would someone want the patent on something like a deep learning algorithm when treating it more like a trade secret would be the way to go? I mean, it's a great technical question, but it seems to me the trade-off of giving away some of the secret sauce, in this case, you're like, great, we'll just keep it behind the scenes anyway.
So, I mean, I think this is going to be a significant issue, right? And I think we'll talk about, we do want to talk about trade secret questions. I mean, the kind of layperson answer to why you would choose patent over trade secret, right, is the mix of rights you get is different. And so what a trade secret will give you is the right to prevent someone else from copying your algorithm. What a patent will give you is the right to prevent someone else from producing an algorithm like this, even if it is independently generated. And indeed, in software today, the overwhelming majority of the patent lawsuits are filed not against people who copied the technology from the plaintiff. They're filed against people who independently came up with their own algorithm, but the plaintiff says, well, it looks too much like mine. So the trade-off for that is, I think, as you suggest, right, that we've got to you got to sort of tell people something. You got to give them theoretically enough information to enable them to make and use the algorithm. My sense is, and Lisa may differ on this, that software companies have been pretty good at writing down enough information in vague generalities, and the courts have been lax enough in letting them get away with it that they don't convey much in the way of useful information. So if what you wanted was got a broader protection, but not to have to give away the crown jewels, right? You might get away with, in this AI context, kind of describing the process of your AI at a high enough level that you satisfy the courts, but don't actually give people the information you'd want.
Yeah, so I have a question. I have a background, I'm an executive vice president of a software services company, and I have 11 patents, right, around US granted patents. Even in the discussions yesterday and generally, I'm seeing that people are talking about algorithms in the context of modern AI, which is really not I believe, the right thing technically, right? So, because it's a very fundamental difference, right? It's not an algorithm that you're writing. When you're writing a deep learning system to do image recognition or anything, it is structuring the neural networks, and then the network learns on its own. And what is important difference is you're feeding all the data, right? As an example, there is some system called FaceNet, and this number of lines of code is only 250 lines of code. But how good the system is only depends on the millions of images you're feeding to make the system learn what a human face looks like, right? And you can then go from there.
And so that, I think, gets to the sort of question of what is it we would patent, right? And so, the kind of easy traditional case would be, I have written a new algorithm. Whether or not that's patentable actually is debatable, right? But that's something we've dealt with in software, right? A second thing you might patent is the training process. People might want to patent, although I don't think they can, the sort of database of training information itself, or you might want the output, right? So maybe what you really might be interested in as a business model is kind of the output state after having been trained. So the kind of neural net once it is trained.
The architecture of the neural network and the weights that you assign to those links, that is what is really, the IP for a neural network, right?
But that assumes that that's static, right? It doesn't assume
Right.
that actually that changes over time.
Yeah, by more training, and the more you train, it will change also. Yeah.
Well, and so this is, right, and this is, I think, one of the issues that is most problematic for patent law. There are questions as to whether or not some of those things are patentable at all. So if what I really care about is the training weights I put on something, that's looking pretty close to math of the sort that we have said is unpatentable subject matter. But even if you get over that hurdle, the real problem might be that if I want to patent what I do is I write down an application, I send it to the patent office, they then do nothing with it for 18 months, then they pick it up and look at it, and then we have a back and forth for a while, and it's 2.5 to 3 years, which is faster than it used to be a couple decades ago, but it's still 2.5 to 3 years before I get a patent. Now, the problem is, right, if what I want is kind of the end state after I have trained the algorithm, the likelihood that end state is going to be very much like what it was 3 years ago when I filed the patent application seems to me pretty low. So the thing I might get is a kind of snapshot of what my algorithm used to do in the past as a patent, and that seems less valuable.
That's not so different.
Out of curiosity, has a patent been granted to any neural network so far by the USPTO?
To what?
Has a
Neural
patent been
network.
granted at all by the USPTO so far, out of curiosity?
Yes, there are a bunch of patents out there.
There are patents on all of these different aspects of AI, and that doesn't mean that all of these patents would be upheld if challenged robustly in litigation for various reasons. I forgot what I was going to say on what we were.
You were going to push back on the question of whether I was getting a useful patent on the end state.
It's not so fundamentally different from other technologies where, at the time you're filing your patent application, often you don't have your final commercial product, and it gets refined a lot in the company as a result of that. You have to give enough such that people can make and use your invention to the extent you have it at that point, and that you're claiming in your claims, and that might require, for certain kinds of things, disclosing the training data, where if that is some unique thing where it's really necessary for someone else to make and use your invention, I think there's a good argument that under patent rules you should have to disclose that.
I think that I think it's right to say this is a problem. This is not a problem that we have never encountered before. I think one of the things that most patent scholars and probably most patent lawyers would say the patent system works better in the life sciences, in the pharmaceutical and the biotech industry. One of the reasons for that is that the time periods are longer, right? So that the thing I'm getting a patent on is actually the chemical that the FDA will ultimately approve several years later. The other reason I think that's important is we actually have a good standardized language for describing what it is that I've invented, so that you can read a patent on a pharmaceutical or a biotechnological invention and have a pretty good idea of what's covered. Neither of those things has traditionally been true in software patenting. And so software patents have been more worrisome, I think, in various respects, right? Because they're vaguer, because they tend to be written with old technology in mind by the time they are issued, and certainly by the time they are litigated. And I guess I worry that sort of AI makes that problem worse precisely because it's not just sort of we're generating a new version of our product and releasing it every couple of years or even every 6 months or so, right? It's that we're actually training and modifying the algorithm in real time. So you've either got a patent on this particular set of weights as a result of this particular algorithm, and its training at this time, which is a snapshot that almost instantly becomes obsolete, or you try to solve that problem by writing very broad, vague claims to the whole concept, right, of training in a particular way, or the idea of an algorithm trained on this database at all, and those seem to me. They might be vulnerable to attack, they might be invalid, but if they're not vulnerable to attack, then they might kind of interfere with a lot of the industry because they prevent a bunch of different people from trying different methods.
The other issue is explainability, right? So the current neural network models, the biggest challenge is explaining how it works. It's not been solved, right? And I'm sure one of the key tenets of patenting is you have to explain how the whole thing works.
Well, and that was Lisa's, I think, why you're suggesting this idea that maybe we could have deposit, right?
Mm-hmm.
That it's sort of like, I can't tell you why it produces, I can tell you how I made it, tell you what I started with, and I can tell you what I trained it on.
But why should that meet the standard, right? Why should that meet the enablement requirement just to have a fifth, like, if you have, like, say it's on a CD to go really old school, what does that get the public?
Well, I mean, if they have access to it, like the.
No, I know, but in this context, right? Like you have something that can't be reverse engineered that way. If you're looking at the result, how does that meet the public policy requirement of enablement, right? How does that teach the public how to practice the invention? If you have a starting point, you have an ending point, but there's nothing in between.
I mean, it's beneficial to them the same way it is to the inventor who now has this system that is, like, for whatever application that system was designed for, they have access to whatever the...
But if it comes with the data, that argument is true. But if you don't have the training data that comes with it, which I think in your proposal, your explanation of commercially, it's not practicable to give the training data as well, right? If you're missing that piece, how does it meet the public policy goal of just basic patenting?
It's not only practical, in some cases actually that
It's
training
impossible.
data is impossible
Yeah.
to share due to
Yeah, like
other
physical media.
Physical media or other legal concerns, which we'll talk about in a minute, right? Yeah.
I mean, if you can't give enough such that other people can make and use the invention, I don't think it should meet the patentability
Although, so,
requirement.
I mean, well, but the closest analogy of how we've dealt with this in patent law are circumstances in which I can tell you how I did it in enough detail that you can understand how I did it, even though you won't yourself be able to replicate it because you don't have access to the information. And that, I think, we have generally said is permissible. So if I said, okay, here's the base algorithm I started with, and here is exactly how I trained it. Here is I've identified the data sets. I can tell you where they came from. Turns out all those data sets are proprietary. Google owns them all, right? And if you don't have a license for Google, you'll never be able to replicate this. I think the courts would still say, you've taught people, at least sort of theoretically, how to do it. They know how to do it. They might not be able to do it. But that's not because they lack the technical ability. It's because they don't actually have the rights to this information. Has
that been challenged? Like, I think that's true where you have a case where the public, like, in theory, they could develop the data that they need or have the web crawling. But when it's something that they just, even in theory with work, could not get access to it, then it seems more like the microorganism deposit requirement where we require the deposit of the material in order to satisfy 112.
Yeah, I know. Look, I see the argument for deposit. Although I mean, the problem is what you really want to deposit, or maybe you'd say, well, if it's as long as I deposit the end state, the post-trained algorithm.
It's different than depositing the cell line, though,
Yeah.
right, in the biotech context, because that you can work from that.
But yeah, and now one thing you can do, I think, is you can do some black box sort of reverse engineering and testing that you wouldn't necessarily be able to do without access to that thing. So if I have access to here's your end state post-trained algorithm, even if I can't sort of kind of understand it, read it, right, because of the explainability problem, I can at least sort of do some testing to try to see sort of what might work, what might not work.
So the version would have to be, I think what you're saying is, if you wanted to play with it, maybe the deposit has to be enough that you can run stuff on it, even though you don't have the original data to figure out how it worked.
The performance will be very different, right?
Yeah,
that may be,
data.
but that's the legal trick, right?
But I have a question on the public welfare aspect of the whole patent system, right? See, yesterday there was a question in the plenary session. Somebody asked Merit J a question, and I don't think it got answered correctly. And it again goes back to this algorithm versus data part of the new model of computing, right? The neural network model. So it all depends on the data. And these big players like the Googles and Facebooks of the world have such a massive amount of data, which in one way I think this is the reason why there is no next Google, next Facebook emerging anyway today, because the current big players have the monopoly on the data, right? Simply because unlike a natural wealth, a petroleum company, something going and occupying a space and drilling, now we are going to Google and Facebook and giving all our assets, right, the data assets, and we don't go anywhere else. And therefore, these players have such a stronghold on the data that in turn leads to these newer models, more efficient neural models.
So I think that's right. One question is kind of what kind of business consequences flow from it. Another question is kind of what, if anything, the law should do about it. In a world in which Google just happens to be well positioned to have access to all of the data because of their existing business model. And I think for a lot of things that's true, right? So if you want to train on, I want to train my self-driving car to recognize stop signs, right? Well, who's got the largest database of photographs of stop signs, right? It's Google Images. If I want to train on a corpus of text, who's got all of the books scanned, all of these things? They didn't do this for AI, but they happen to have built these sort of enormous set of databases. In a world in which they were not also in the AI development business, right? Then they might actually sort of be perfectly happy to license those access to those databases to AI developers who wanted to train on a non-exclusive basis. Maybe not, but they wouldn't have some sort of interest in making sure that their cars and not competing cars had access to them, for instance. But if they're vertically integrated, right, if they're going to use if they own both the training data set and they are the ones developing the algorithm, then I think it's right that they do have a substantial structural advantage. Now, the thing I'll note about that is that's not mostly it's not mostly IP law that is giving them that structural advantage, except to the extent that that it prevents other people from just copying the database altogether.
So if we bring antitrust to the question and we combine the disclosure proposal that you have with essential facilities, it becomes really an antitrust issue, right?
Yes, if you're willing to say basically you have to share this because the world you can't compete without it.
Yeah, but the argument that we heard just now is so critical that it's Google that basically always has the structural competitive advantage that you mentioned, right?
Yeah, I was just going to say to that point that the law is not always coherent, right? And you have two actually opposing forces between IP and antitrust law, right? IP law, I think Lisa can tell us how patents are a government-granted monopoly by definition, right? And then you have antitrust, how when you aggregate, so like the question becomes, let's imagine you can patent elements of AI, although I don't know that algorithms are the right part of it. I agree it's maybe more systemic, but let's say you can patent parts of AI and you amass this giant pool of patents, right? Then at what point does the interest of IP law, which is definitionally, I share with the public, open kimono, everything I've discovered for exchange for a 20-year government mandated monopoly, at what point does that, while legal, then brush up against this other body of law which is competing, which is antitrust? And then maybe, I don't know, like Frand, to me, I mean, that was the interest to your question about why don't we have a regime that forces people to license their data pools and data lakes and access to this mass amount of data? that regime exists with FRAND rule. I mean, Europe does a much better job.
If you commit to it voluntarily is the issue of the
Yeah.
FRAND rule.
Well,
Well, yes.
yeah, but at what point? No,
Yeah.
I'll shut up.
Well, no, I mean, see, yeah, so
that involuntarily cross. I mean,
So there's a bunch here. So let me try to start at a couple of things. So I think antitrust law, there is a doctrine in antitrust, essential facilities.
You don't know what FRAND is.
Yeah, no, we'll get there. There's a doctrine in antitrust law called the essential facilities doctrine that says some things are so critical to competition that you have to share them with your competitors, at least if you're vertically integrated. So the classic example is I own all the power lines in the state of Wisconsin, and I refuse to allow my power producing competitors to interconnect with them. The court says, no, you've actually got to interconnect and allow them to sell power that goes across your lines, because nobody can, we don't want everyone to build 3 or 4 or 5 different completing power grids, right? We want them to share the information. That doctrine in the United States is very, very rare in application. There's some people who think it's actually affirmatively dead. I don't think it's affirmatively dead, but it's sort of the last refuge of somebody who's otherwise got a good argument. It is much stronger in Europe, right? And so I think one thing that's notable here is we might well have a different legal regime in a world in which the European courts said, hey, competing AI developers have to have access to Google's training data set, and the US courts say, no, we wouldn't do that.
I think that gets a little bit to what you were saying earlier, right? Which is currently, if I understand it correctly, what you're saying is, I can tell you the how. I don't have to give you the goods to do it, is one way to think about this.
Right, and essential facilities would be an argument that says, yes, you do have to give me the goods to do it.
There's the tension, right?
right.
Can I just, we talked about kind of what is possible potentially for patenting. What is actually the current field and being able to uphold those patents? Because I think that's almost more important rather than what a body decides that hasn't been tested, right?
So part of the answer is we don't know because the patents are relatively new, and so it takes quite a while for them to make it into court to get answers in a specific case. Part of the answer is we don't know because a lot depends on the scope of this doctrine of patentable subject matter. So what we say is you can't patent an abstract idea. You can patent sort of specific applications of an abstract idea. Courts are all over the map on what constitutes an abstract idea. We go back and forth. We don't have a lot of guidance. So it's really hard to tell. If I had to hazard a guess, I would say that both algorithms that one starts out with and kind of things like weights that you've done for training, and the training data sets themselves, I think are hard. Those are going to be hard to patent in a way that survives, that upholds. The Patent Office may well be granting them. The Patent Office has sent some signals in the last couple of years in the new administration that it wants to patent more of these things, but it is not the party that gets the final say in whether or not they're actually valid. So I think a lot of those things are problematic. I think if you've got a method, if I've got a kind of new way of actually sort of training, or a new way of actually generating results. So, the first person who comes up with a generative adversarial network, for instance, right? That seems like a sort of thing that actually improves the operation of the computer itself in a way that probably the courts would say that's okay. And I think implementations, especially if they're in physical hardware, are probably going to be okay. So if what I have is, if what I claim is a car that actually recognizes and stops at stop signs that I got through AI, I could probably patent that because it doesn't feel like an abstract idea. That feels like a concrete implementation. That said, these are guesses, right? They're, we don't know for sure. I'll make one other point though, right, which is it may matter less than you think it does whether or not these patents are valid. I think a lot of the value and a lot of the use, especially in a new technology that people get out of patents, is not, I will sue my competitor and keep them off the market or make them change their products. That sometimes happens. It happens in pharmaceuticals, but it doesn't actually happen all that often in software, right? And even in the rare cases it does, like Apple versus Samsung, right? It's not obvious that Apple winning that case actually changed very much in the marketplace, right? The values of patents might be anything from startups being able to kind of stake out place and signal to venture capitalists where they are, facilitating kind of business deals and trades that are really about know-how or licensing of kind of intangibles, but now I've got some actual things that I can attach to them. And those values you might get that value whether or not the patents would ultimately 5 years from now turn out to be valid.
I think that's right. And one good example of that is one of the main lawsuits we've seen of people arguing over this technology is the Waymo Uber case, where there were patent claims, but they were not the strong, like it was really about the trade secrets.
Right. So maybe actually we can use that as a fulcrum. So I think one of in part because it takes 3 years, right, in part because of this kind of definition and disclosure problems, I think what you might say, look, patents just aren't the best fit for AI, and that if what you've got is a really good set of weights that have results from your training data set, the thing you should do is keep it secret. Jim, you want to?
Yeah, I mean, secrecy is the oldest form of intellectual property, right? It's been used for millennia, and it does, as Mark points out, unlike patents, it doesn't give you the ability to exclude others, and you always have the risk that someone else is going to come up with something. But software structures, software itself has been protected for a long time through secrecy, and which can be very, very powerful because, particularly if you don't have to trust anybody with any instantiation of the code. Right, as we have now with the cloud, all you
have to trust Amazon with your.
Well, yeah, right. But you can deal with that in contract, right, and figure it out. But the point is, all your customers don't get anywhere near the code. They just query the tool and they get an answer, and that model is very robust for protecting software innovations and for AI. And so my assumption is, and trade secrets are the area that I work most in, my assumption is that most of what we see with AI will be protected through secrecy. Secrecy protects information, not inventions, not little teeny things, but information, data in all its forms, extracted, raw, what have you. All is protectable by trade secrets. But the challenge, I think the greatest challenge is going to be for AI applications that affect public health. There will be a demand for transparency. And because everybody wants to know, how is that algorithm that decides whether the car is going to kill the baby or grandma, when it has to go one way or another, or solve other ethical problems. People are going to want to have that understanding. The problem is, of course, if you have transparency, it's completely incompatible with secrecy, right? It's and if you don't provide secrecy as a payoff for investing in the development of the tool, where are you going to get people who will, put in all that investment and make the tool? So this is a conundrum. I mean, we had this, as I pointed out in something I wrote recently. We had this issue around pharmaceuticals over a century ago, and we created the FDA. So we had people who could look at this stuff, who were competent most of the time, and could pass on whether it was safe and effective. And you might imagine in some world where you could do something like that to preserve the secrecy of the AI tools. But then, these are things that are dynamic. They keep changing. A molecule is the molecule and it sits there. So how do you handle this? I don't know. I'm interested in what other people think about that.
So just to note, I think while this is a huge issue with sort of health and safety, right, and people, the medical regulatory folks are going to be very nervous about we have a robotic AI surgeon, but we won't tell you sort of how it works, or we'll diagnose, but we won't tell you how we make decisions. But it's not limited to medical.
Well, that's right, and you have places, we were talking at lunch. I mean, in France, There's been very, very strong arguments about any tools, any AI tools that possibly touch on human experience will need to be,
We want them to be
Unshrouded.
explainable, right? And
what does explainable mean?
my personal feeling is we just need to get over that to a large extent, right? Because it's not, I don't know that it's really feasible, at least not at cost of changing things substantially. But for some categories of information, and I think these are some fairly significant categories, we're going to want some amount of that. So it's not, in addition to health and safety, I'll say sort of policing and criminal justice, right? When I am sort of stopped, right, on the basis of an algorithm that sort of predicts my sort of likely criminal behavior, and I want to defend myself, one of the things I'm going to want to do is to be able to say, well, hey, wait a minute, did that pick me because of my race, because of my gender, because of some other category? To do that, I need theoretically both access to the algorithm, right, which the companies that provide treat as a trade secret, and some ability to understand or at least query the algorithm to kind of run results that will allow me to test it.
And this is a live issue in today's criminal justice system where, and Rebecca Wexler and Natalie Ram each have a great article dealing with this problem where like AI is being used in sentencing and forensic, like various things where criminal defendants are faced with these, and it's being protected under a trade secret privilege.
Yep.
Although it should be noted, it's not a question of using AI or not here as much as, to me, it's a question of using AI versus using a person who has many of the same biases and is also equally unexplainable or sometimes less. So the doctor, with the doctor looking at a chest x-ray and diagnosing pneumonia, the doctor may not be
I want a right to explainability, right? Yeah,
right, well,
yeah.
Or a judge sentencing a defendant, right? Either if there's evidence too that judges make pervasively biased decisions. If it's an unconscious bias, they're not aware of it, and if it's a conscious bias, the judge is extremely unlikely to say, I gave this person a longer sentence because of their race. So, the human mind may be as black boxy as some of these neural networks, and for me as a patient, not that explainability isn't important, because it is, but as a patient, I'd be much more interested in hearing, well, what are the outcomes of the robot surgeon? And if they're better than the human surgeon's outcomes, but you have no idea how the robot does it, I'd probably pick the robot surgeon.
But there's a little game you're playing here, I think, because look, in theory, judges have to articulate why.
Right.
People get to ask that question, and even if it's subconscious or not, over time, we might start having more statistics on, it turns out, you put brown people in jail, you do this to women, you do this to whomever. Yeah. It's not perfect, and I think the subtlety in what you just said there is, a robot surgeon, we have product liability issues. With doctors in malpractice, there are experts that say this was good standard of care or not.
Well, and you can examine the doctor too, right? You can examine the doctor too. I mean, you can ask them to explain, and they have to answer.
And we have something that feels like traction, albeit fuzzy to your point. The difference with software is maybe instead of explainability, right, Deirdre's been calling this contestability. Josh Kroll and I have a paper where we talk about using possibly a CS hack called a zero knowledge approach. Like presenting engineers with, look, what we really want is how do we know that you obeyed a spec, if it was a legal rule, or that this thing is not crashing as often as it seems to be. And that's, I think, where engineers can go, oh, well, if you've given up on this crazy explainability, because most of the engineers I talk to say, forget it, but you say, build me something that you can show with high confidence, this is how it works, other people can test it. Now you're in a world that's more plausible to the engineering community.
So I agree with that. I guess I'd say a couple things. One is, I don't think that's inconsistent with what Ryan is saying because, right, while we can confront the doctor, we have experts who will come and testify, right, a lot of that is actually anecdote masquerading as expertise and knowledge, and that we may be a lot the world of human decisions may be a lot less transparent than we think it is. We may be less good at telling whether people are lying, less good at telling whether they're confident in their opinion because they're right or just because they're confident, and so forth. So the trade-offs are comparative. The other piece I guess I'll note is I do think even if it's not explainable, the mere fact that we get large pattern outcomes may enable us to find things that trouble us in AI that don't, that we wouldn't find otherwise, right? So there's a great example of employment algorithm, right? Sort of screening people for employment, and they are very careful in designing the screening algorithm, right, not to take race or gender into account. But they are also very careful to kind of learn from who gets hired, who gets promoted, various other things. And then somebody sort of decided to kind of run a predictive testing on the algorithm, and it turns out that the two things that are best predictive of success are being named Jared and having played lacrosse in high school. And those are not because lacrosse is a great skill at whatever job this is, right? Those are because the computer's done a good job of finding proxies for rich white men. And we said, don't take this into account, but it went out and found that, hey, you know what, actually, rich white men are doing better in the hiring and promotion decisions, and we can replicate that.
Because it was built to probably echo.
Yeah, right, and you can look at that and you can say that's a problem, but I look at that and say, that's a problem we had beforehand, and now we can see and document that it is a problem. So there may be information that we get access to, but this, to bring us back to the trade secret point, right? That's all available only to the extent that sort of some of this information is kind of turned over either to the public at large, or at least kind of to criminal defendants, lawyers, to somebody, a social scientist who can test it. Now, you might not need to sort of turn over the actual thing itself. You might, the Jared and lacrosse stuff you get by kind of black box testing the end state.
Right. You can imagine structures in which you would take the thing and there would be certain queries you could use that would solve everybody's problem. But that's the conversation that's going on right now is really about, I just keep hearing this, transparency. We want the whole thing laid open. We don't want anything lurking inside that we can't see. And we're going to need to square that circle.
Can I just ask something?
Yeah.
Is it really about the transparency? So I'm from Europe, and I'm a European diplomat based here. And for me, for example, this judicial decision predicting criminals for me, this is not really so much a problem about human bias versus machine bias, but about taking away responsibility from humans. Because in the end, if I am a bureaucrat, and if there is an algorithm suggesting something, I cannot really then, it's the safe thing to do, is to do what the algorithm suggests. So in a sense, if you're a judge, that's the nature of a judge. He has to think for himself, and even if he's biased, at least it's a human being responsible for that, which you can contest. If you start bureaucratizing everything to machines, in a sense, you take human responsibility out of the equation. And I think that's the bigger problem than just measuring success rates of predictability between machines and human beings. Because what are the judges then there for?
Yeah. So I think that's I think that's right, although it does raise to me the question of sort of why we want human decision making in the loop. And so there are a couple of possible answers to that question, right? One possible answer is we think humans will make better decisions, right? That sort of so Europe now has the right to a human decision in the GDPR.
Not better decisions, but human decisions.
Well, okay, but so right. So I want to distinguish these two things, right? So I think one argument would be humans will make better decisions. That's a testable empirical proposition. I think it will ultimately probably turn out to be wrong in a lot of these cases, right? But you could, but what I hear you saying is something different, right? Which is that there is some value in having a human make the decision over some things that control my fate, right? And that might be true of criminal justice and criminal sentencing.
The President of the United States, so would you like an algorithm?
Yes, in a heartbeat, please.
Probably decisions, but you can't vote for an algorithm.
We're working on it.
But so the question, I think on the kind of do I want a human decision, there may be a kind of sense in which we feel that humans are sort of happier if they feel that they have been heard by another human being, even though they get worse results. Right? And there's some psychological literature that kind of points in that direction. The question is how much should we be willing to trade off against sort of bad decisions? And that even in sort of criminal law context, I mean, It might depend on how much bias we think there is. I mean, it strikes me as not crazy if you were a sort of black man in America to say that you would rather have an algorithm decide whether or not a cop is going to pull his gun on you than have a cop in the moment decide to do it, right? And I could be wrong.
Right point too. I know at first I was like, no, but at some point, the systems I think are diagnostic, right? So what you're saying is deference to me is what I'm hearing you say is total deference where a judge just isn't doing anything. That's probably got some issues because someone somewhere should be testing, was this good software? Asking ex post, unfortunately, but most of law works that way. These rules, are they working as they were implemented? But if over time something says always Jared who plays lacrosse, someone should go, whoa. Or the somewhat infamous Boston Popple example that Kate Crawford talked about. What was good is the rest of her paper, if I remember pointing out, they worked with BU and very quickly said, that's absurd. Just visualize this data. There's no way it's only rich neighborhoods that have potholes. It's being not too deferential.
But someone has to look at it.
And to reveal, as you point out, this point, data at scale and good software might reveal, whoa, we didn't even know there's a whole bunch of systemic bias.
Although someone could be another AI.
And indeed, the first point you made about wanting to have human judges was a comment that said we could aggregate what human judges are doing and see if they've got bias over the long term. Although France has recently implemented a law that prevents you from doing that on penalty of 5 years imprisonment for aggregating judicial data, but we're really picking on France.
I'm a felon in France for starting Lex Machina.
But AI indeed, I think is going to be a lot more correctable than people, because if you have a judge tending to make racially disparate decisions, right, that's always explainable. And even if a judge agrees to say, all right, I'm not going to do that, very hard to get someone to internalize a new rule like that. Whereas with AI, you can just make a rule and say, now sometimes you have to track down it's using Jared instead of male, but I mean, you can make a rule and say, optimize this, except you can't take these things or these proxies into account, and you can always improve it.
So, and to bring this back to sort of IP and trade secrecy, right? I mean, I think the value from an intellectual property perspective, I think trade secrets actually, as Jim suggests, probably are the right match in a kind of economic sense for AI. Part for the reasons he talked about, but I'll mention one other, right, which is it's cheap. Right, you don't pay anybody to write your patent. Well, no. I mean, if you
have to prove the stand, right? You don't get trade secret protection just because you call it that.
Well,
it's worth explaining what you have.
Yeah. You go to
keep it and on non-public data.
If you go to court, everything's expensive.
Yeah.
But from the kind of perspective of a
manage.
there is a cost, absolutely. But I think it's substantially less than sort of I want to patent everything, and certainly if I want to patent sort of kind of snapshots of my invention.
And like us that are not familiar what those costs would be, like what that looks like.
Yeah.
What the cost would be of
a trade secret management.
Yes. You have to figure out what the risks are of losing or getting contamination of your most valuable stuff, how likely those things are to happen, and then you're presented, if these things are truly important to your organization, then you look at, well, what am I willing to spend on mechanisms that will reduce that risk? You know, we're going to put in more guards. Are we going to have fewer people that get access to it? We're going to be less productive as a result. Every bit of every security mechanism has a trade-off in terms of actually, money cost or inefficiency in doing what you're doing. So you aggregate all of that and pay attention to it, and you can see that it's not free, but although I absolutely agree with Mark, it's less expensive.
And it's also
any legal.
No, but to make it
you have to show that you have taken reasonable efforts to protect the secrets.
Right.
And so
treat it like an actual secret, right? You can't just say, I would prefer other people not to find it, right? You restrict access many ways, right?
But I guess what I would say is, right, sort of, I do think it is cheaper than sort of patents in the long run, but I also think the marginal cost is close to zero. That is, these are things tech companies are already doing anyway, right? So most of the things you would do, right, sort of badged access to buildings, right, kind of password access to computers, right, are things tech companies are doing maybe ultimately for trade secret reasons generally, or for some kind of general security reasons, but I don't think the law is going to sort of require you to spend a lot more money doing things you wouldn't otherwise do.
Right, whereas each patent application will cost you thousands and thousands of dollars.
Plus privacy law, right? Big companies, right? Google was, when I was there, very serious about how many people had access to data. The rules were very secure. So any company doing data work, interestingly, you get a benefit. Trade secret security, you're also showing that you're trying to be private. So you actually have two reasons where, as a cost question, you're going to be doing this.
We're going to do access management.
I think so, right? And you actually look good, because by doing that, in terms of, though data breach is still a problem, you actually are complying with another piece of what you should be doing as a company.
So it seems worth noting from an IP perspective that there's two different conversations we've been having in the past 5 minutes. I mean, one is about whether we should be using AI versus human decision makers in different contexts, like when are we going to be using AI, which, I mean, it's not really an IP question, it's an important law and policy question. Then there's the separate question of, given that AI is being used in various contexts, whether it's criminal justice or medical or other things, when should society require disclosure, and what disclosure should be required about that versus allowing it to be protected through trade secrets? And I hear Jim saying, like, raising the concern, when you require disclosure, that's taking away some of the incentive to create it, which is the kind of problem that IP is concerned about. Yeah. And we should remember that secrecy and protection and exclusivity is not the only kind of incentive we have for producing these things. And so when we're talking about something where, like a medical technology that's being used where there might be a huge public interest in other people being able to test and build on it, there may be other ways to, through the regulatory process, provide a reward to the people who develop it in exchange for the disclosure. So just by saying you can't keep it as a secret doesn't mean that there aren't other things that the legal system can do to provide incentives.
Yeah.
A bit more, I don't know if this will help, about the property over the data.
Yes, so actually just where I wanted to go now, right. So, because I think one of the things we've established is like the training data, right, is one of those sort of critical pieces that differentiates this from other things. And so I think there are kind of two dimensions in which to think about this, right? One is as the user, and one is as the owner or possessor. So from the user perspective, right, AI isn't going to work unless I have very large, very good training data sets, right? And some of the issues we've been talking about transparency, about bias, and various other things are going to be influenced by not only sort of how big it is the training data set, but how is it constructed. Right, so a lot of the bias in algorithm stuff has turned out to be kind of small number problems, right? So we don't have very many facial images of people from American Samoa, and so we're actually less good at recognizing them, right? So if you don't oversample, if you don't build a training data set that's sensitive to those problems, you end up in trouble. Everybody wants good training data sets. Training data sets tend to be facts about the world, fine. Pictures, images, videos, text, various things. Almost all of those, except facts about the world, are copyrighted. And the key thing about them is that sort of those copyrights are owned by a whole bunch of different people. Right, so Google has collected a really large group of videos, and it can process a lot of information and learn things about videos. It didn't make any of those videos, and because of the way sort of Google works, it also didn't collect that database by going out and buying all of that video content from everybody, right? It set up in YouTube, it set up a site where people could upload their own content, sometimes the content of other people. YouTube has a legal right to use it, subject to certain conditions, right, for the purpose for which they are using it traditionally, which is kind of make this video sharing site available to the public. Similarly, the search engine, right? We went and crawled all of the internet. All the text on the internet almost all of it is copyrighted. We collected all that stuff. We didn't get licenses and permission from everyone some caveats around what you think the robot exclusion header does, but the court said that's permissible, that's a lawful use because you're doing something valuable with it for the world, right? You are creating a search engine that allows people to find what they're looking for. It's not clear that Google's taking that database it has built and has a right to use to provide search results, right, or to sort of share people, and saying, I'm going to use this to train my self-driving car, or I'm going to use this to train my personal assistant, will be a fair use of that material. Right? And if it's not, well, there are a lot of different copyright owners out there, each of whom could have a lawsuit, and could have a lawsuit not just for sort of whatever kind of minuscule share of the sort of value of the training data set there is, but we have in copyright law, unlike patent law, statutory minimum damages that generally far exceed the value of the sort of individual use that you might make here. So I think one issue if you are a kind of training database user is, right, is it actually going to be lawful for me to use a training data set for this purpose when all the stuff in it is owned by millions of different people?
Question.
So how would that argument apply in voice?
So interesting. So I think the same issue would apply. So voice is a little more complicated because kind of truly unplanned conversations, generally speaking, are not copyrighted. But they can be made copyrightable in relatively easy ways. So anything that is an audio communication, that is a movie, a play, a concert, anything that's scripted, or anything that is recorded with the permission of the person speaking, those things get copyright protection. So if you wanted to run an AI in voice and you could sort of somehow find only sort of unscripted conversations out on the street between people, you'd probably be fine. On the copyright side, you might actually now be guilty of violating the surveillance and wiretap laws, but that's outside our scope. But once you're in the world of, well, where am I going to find good examples of voice? I want to go, find kind of television performances, all that stuff is going to be copyrighted.
So some jurisdictions like Japan have text and data mining and such exempt, but you were going to talk about that next.
No, go for it.
No, I was going to ask you what you thought about it, or what we should be doing in the States, or with the Google Books project, for example, where they went and digitized everyone's copyright books, and now they're training their AI on it, and that was held to be a fair use. Well, not the AI training yet, but the digitization. Yes.
So I represented Google in the digitization case, in the copyright case.
Well,
so
well done, sir.
I'm very happy that we were allowed to actually digitize all the world's books and make snippets available. But I don't know that a court would necessarily conclude that because that was legal, that putting it into your training project is going to be legal. And I think it may well be the case that even if a US court would conclude it, a European court, which has a much more restrictive copyright regime right now, probably wouldn't reach that conclusion. Interestingly, as Ryan points out, Japan has gone in the opposite direction. A new version of the Japanese Copyright Act writes a specific exemption for training data sets from copyright law, precisely in order to encourage people to do this.
Right, so the European New Copyright Act also has one of those, but it's more restrictive than the Japanese one.
Yeah.
What's the claim under copyright in terms of, let's pretend we have the money to just buy it, first sale doctrine of sorts, build my set, and use it in the background to train my data. Where's the copyright violation if I'm training?
Who are you buying it from?
Let's say I go to, let's say Amazon, and I actually buy it.
You buy it. No, but why does Amazon have it? Right? Amazon has it because they made digital copies of all of this stuff under a fair use exemption from copyright infringement that was tied to their specific use. And now they're making a different use of it. That different use might also be, I think should also be permissible, but it is, I can imagine a court looking at that and saying, wait a minute, this isn't, right, you're not transforming the work in the sense that you're kind of providing the sort of consumer with the kind of snippet that allows them to find it. You're just taking this stuff commercially and dumping it into your self-driving car program.
If someone took the Google approach but with cash and said, I'm just buying a corpus, not scanning. And then I scanned it. and then I train on the back end. Where's the copyright claim? on
Wait, because you made a copy. How did you scan it? You made a copy, yeah, right? I mean, this was the whole problem with Google Book Search. They had legal access to all the books they scanned, but scanning it makes a copy. And the publishers said, hey, no, that's unlawful. Now the court said, no, that's permissible because it's transformative, valuable, but it's not obvious that they will come to that conclusion. I think they should, but reasonable people can differ, and there's a lot of money if you're wrong.
I'm trying to find a solution to the problem of propagation of deepfakes. And so in this situation, and I have a patent that's related to that already. So in a situation like this, where Google, Microsoft, Amazon are all creating deepfakes of, say, Elizabeth Warren, what is the rights and what is my right now to use that?
So, I mean, I think if you're using it to try to sort of catch and identify deepfakes, it'll probably be permissible. But it's not. I mean, you'd still have to walk through the copyright fair use analysis. So, copyright law. If you make a copy of something in whole or in part, right, you've triggered copyright law. In the U.S., we have a fair use defense. That's a multi-factor, case-by-case, we know it when we see it test for figuring out some combination of, is this good for the world, and are you taking money away from the copyright owner?
But you're still infringing. I think that's,
yes.
The point is that it's still an infringement.
Yes, right. But yeah, so right. But
So if Google creates videos, like thousands of deepfake videos of Elizabeth Warren in all kinds of sexual position or doing all kinds of crazy things, Trump or whatever, that's okay?
is it okay?
Without consent?
Well, so the answer is I don't think it should be okay, and I think it might not be okay, but it is probably not copyright infringement.
Well, it's going to be infringing the copyright, depending on
but not of
the
Elizabeth
people,
Warren's
the
rights.
videos that
Yes.
you're starting with.
You start with like images of the real person.
Right.
Yeah, so all of those videos and images you're starting with, whoever owns the copyright in them, you are probably infringing their copyright, and they're
Right.
are.
But the photographer might not. Photographer is not necessarily the person who objects to this, right? The person who objects to this is Elizabeth Warren. She doesn't own the copyrights because she didn't take the pictures. And so this has actually come up in some of the sort of sexual privacy cases involving not deepfakes but revenge porn. Right, where kind of people are in a relationship. The one party takes a picture of the other unclothed. They break up. They then the party who took the picture posts it to the internet. The party who's injured, right, who's the person depicted, doesn't own the copyright in that image because they didn't take the picture. The copyright is in the sort of person who took the picture.
Yeah, I have a question. Let's say I'm an artist and I write an algorithm and train the algorithm with all the texts of Franz Kafka. And I want the algorithm to produce a new Kafka text. So I understand that the training set, there are these copyright protections of whoever owns the copyrights of the Kafka text, but what about the product?
Yeah.
So I find that fascinating because it deals with human creativity versus AI creativity, and the same, of course, question: how about music created? Is it the ones that write the algorithms?
Make a song that sounds like Taylor Swift.
Yeah.
Right? So I think this is a huge, really interesting question, and there are kind of two different pieces to it, right? There is the has the algorithm that wrote a new Franz Kafka story done something creative that sort of warrants copyright protection? And if so, who is the author? Who gets the copyright protection? And there's a second question of, in the course of doing that, are you infringing Franz Kafka's rights? Right, because even though he never wrote this story, right, you have collected together his works, and so the thing that you have made is presumably something which is not identical to anything he wrote, but is similar at kind of some level to the things he wrote.
And for those who aren't familiar with copyright law, you are liable for copyright infringement, not just for making a direct copy, but for making anything that is substantially similar. So if you are inspired by some other work, writing your own sequel that involves some similar themes and characters, like that can also be copyright infringement.
So Marvin Gaye, for instance, was just one copyright. His estate has one copyright suits against people who wrote new songs, different songs, but that sound quite a bit like his songs.
So I just wanted to come back a little bit on the YouTube example, and I don't know how it fits in with patent law, but it's something I'm kind of copyright law, which clearly is important for the data sets there. So I heard you say about like the book example where there seems to be like a lot of public good, therefore like it was judged to be kind of useful, therefore permissible. So I'm just thinking through, like, how does that work for using data sets for which not specific permission has been given? First of all, like, how would that be judged eventually, such as in the case of YouTube, if it would help prevent, I don't know, people committing suicide? Giving an example, like being able to derive algorithms from that. So that's one. And then secondly, what's the best way, thinking about creating data sets for which, what's the best way of getting permission for actually using that data to train algorithms?
Yeah, so, and this is, so it's a good question. So let me start with the second one. So the problem is, and the reason why I think, we ought to want this to be a fair use is, if the answer is, I have to get every photographer's permission who's ever taken a photo that's on the internet, that's never gonna happen. And so what we'll end up with instead are kind of small and non-representative sub-libraries for which I can get permission. Well, Getty has a certain set of pictures and they are more likely to have this characteristic, and so that's what we'll train on. That strikes me as bad from a training perspective. We'd rather have access to the best possible corpus, but it's really hard to do if the answer is you have to go get permission from everybody separately. There's a second layer to the question, though, I think, which is somebody has compiled all of this stuff. Google has this large database of photo images. One question is, can they use it? That's the fair use question we've been discussing. A second question is, somebody else wants access to that stuff. I want my self-driving cars to stop at stop signs too, right? So I want sort of good training to sort of identify stop signs that aren't sort of marked in some electronic map. Now, I can imagine Google saying, well, yeah, we built this database. We put a lot of effort into it. It's true that we built this database using the fair use doctrine, but you shouldn't be able to just copy our database outright. You could come buy it from us or come license the right to us if we're willing to sell it to you. But if you're a competitor, maybe we're not willing to sell it to you. And so I think this goes back in some sense to this essential facilities idea, right? And I don't think US antitrust law will get there on essential facilities. European law might. But there may be other ways to get at it. So there's an interesting Ninth Circuit decision this year called HiQ that suggests that it might actually be permissible to try to sort of scrape somebody else's public database. In the past, we've used laws like the Computer Fraud and Abuse Act to restrict that. We've used efforts to sort of put a contractual terms and conditions thing on the license to restrict that. And the law has generally enforced those restrictions, but it may be that courts are more willing to say, yeah, you know what, if what you've got is a bunch of stuff that is not itself belong to you, it's in your database, and I want to come and scrape it from you, maybe that shouldn't be unlawful. And that would be a way of effectively getting the kind of essential facilities competition. It's not you must affirmatively share it with all your competitors, but you can't stop people
as long as they can access the database.
As long as they can have access to the database.
And in Europe, then you have also the database directive and copyright protections of databases. So Europe, well, after you.
No, go.
There's a question back in the corner also.
I was wondering if we could return to that downstream question of machine creativity.
Yes.
Whether machines can actually hold intellectual property rights. Because I think current understanding of US patent law is that there has to be a human inventor. And so it creates perverse incentives to suggest that there was a human involved, even if it was an autonomous machine that did the creation. And my understanding is that in the UK and Australia, there's been a little bit of a shift recently. And I was wondering what the thoughts are around this.
Yeah, and I think the answers might differ depending on whether the output of the AI is a potentially patentable invention, or whether it is a novel, a copyrightable novel, Franz Kafka. So Ryan, you want to start on the...
Can I just add a little bit to
that?
Because I was thinking about the Taylor Swift example is kind of interesting, because I think there is the AI out there available that if you don't only take Taylor Swift, but you take Selena Gomez and 2 or 3 others similar.
Current hot
feed
pop
all
music.
of that into the AI so that not any of them can say it's significantly similar to them individually, then is it okay?
So
and that's kind of this creativity.
So I think
around it.
I think the answer is yes, it's okay if it's not too similar to any one of them, right? That's our pop music, our non-AI version of pop music right now, right?
But you could say the same thing for television shows.
Exactly.
Or,
Yeah.
you know.
No, I think that's right. And so the answer is yes, as long as what you're doing, even if it's kind of derivative, if it's not sort of too derivative of just one person, then it's permissible. You can do it.
So the question's not a process one. It's a, like, does the output from the perspective of a ordinary listener sound similar?
Well, the whole point would that be that machine can come
Right.
up with a formula that's gonna please people's
Yeah,
tastes.
right. Yeah, but yeah, Lisa's point is an important one, right? Which is maybe you want to.
Yeah, so the question is not like, did I feed in 3 different musicians and thus none of them would have a claim as a matter of the process that I used to create it. It is, given whatever the output is, would a ordinary listener, which is the standard we use in copyright law, think it is substantially similar to any of these other songs?
So if the answer is I fed in 3 different boy bands and they all sound like NSYNC because all 3 of the bands sound like NSYNC, and so the resulting output still sounds a lot like NSYNC,
Then all 3 of them could
I'm
have a
copyright
claim.
infringement, right? I am
It
infringing.
wouldn't be if the producer found a whole bunch of boy bands and said, "I've got your sound in reality."
Well, no,
Sure.
no,
If they made it too similar to one.
That's exactly the edge that would happen, right? Is what back to once we put the human in the loop, and the producer's like, I produce boy bands, I produce young pop stars, and they all use auto-tune.
I disagree
It's
with
still
that,
copyright
Devin.
infringement
Yeah,
under
so
current law.
this is blurred
What's
lines.
happening, just to
This is-
clarify, is they're not suing each other only because they happen to be under the same corporate umbrella.
Well, all
That's
right.
your point then.
No. This is
If
blurred
there's a-
lines.
The point is whether or not you're automating, you still have the same test, right? And
Our
so-
point is it's infringement, even though humans do it.
Yeah, but the irony is in practice, right? The
No.
machine that is the music industry will produce people who absolutely are told sound like this with a slight variance, but they're hitting a genre.
Well,
They have to
and
get the
some
slight
of them-
variance just
And
enough.
if they have to
And
vary
the
enough,
machine or the voice.
or they get
Right.
sued. This is
Okay.
what happened in the blurred lines case, and they lose to Marvin Gaye, right?
Right.
Yeah. So, all right. So, but let's go back to this question, right? So, because I do think, right, we've got sort of both who if anyone owns the output of an AI, if it's a technical output, and then who owns it if it's a copyrighted output? And why don't you, Brian? Why don't you go with
Well, I'll start with the patentable output. So people have been claiming machines have been doing this since the 80s, but it hadn't until very recently come up as a case. But it may be a substantial part of what AI is doing now in things like the Watson Insights business model. So companies give big data to IBM, which runs the data through the suite of algorithms that are Watson. It produces some output. That output's an insight. It belongs by contract to the client, and the client can file a patent on it. But it isn't clear there you've really got a traditional human inventor, right? Because if they just handed their data over, that doesn't do it. If they commissioned research, that doesn't do it. IBM's not an inventor because companies can't be inventors. Maybe the people who program Watson are curated or trained it on data, but probably not if, well, there could be hundreds or thousands of programmers, but if they didn't have a specific expectation of the problem they were going on to conceive of, that wouldn't make them an inventor. Maybe. Well, sometimes.
I mean, accidental invention is a real thing.
Well, accidental invention is a real thing if you were the first person to recognize the patentable subject matter of the output. And if Watson says, here's 1,000 ways to design a new aircraft wing, and someone goes through them and says, I think this one's going to work, right? That might be an inventor. But if Watson says, I asked Watson, give me a better aircraft wing, here's all of Boeing's data, and Watson says, here's your aircraft wing, and you say, great, I'm going to file a patent on this. If people were doing that, if IBM was going to a team of human researchers, or Boeing was going to a human team of researchers and saying, I want a better aircraft wing, here's my data, and they come and say, here's your better aircraft wing, and you say, great, I'm going to be rich, let's file a patent on this, that wouldn't make you an inventor, right? In the same way, if I train my PhD student or I have children, I'm not an inventor on their patents, at least without conceiving of the direct invention. So we filed a couple patent test cases, a group I'm leading in the US, the UK, Europe, Taiwan, and Israel now that got announced a couple months ago, and they were autonomously made by an AI. It was a neural network system. In its 90s iteration, you had one neural network trained on data. It would perturb its own connection weights, corrupting its data and outputting novel data. And you'd train a critic network to evaluate the outcoming data and say, I'm looking for something interesting that meets these criteria, and this new output does that. right? Some of the time someone in there may be a human inventor and some of the time maybe not. If you're just asking it to solve a problem and giving it some very general stuff, now these machines have thousands or millions of neural networks working together. Each network encodes a conceptual space, so there may be a network for academic and a network for boring and a network for escape, right? And it gets trained to combine them into simple ideas like escape an academic lecture that's boring. And if you combine it with
Too
another
close to
idea-
home here, right?
Too close to home. I can jump out a window, but I'll die, but flying devices may let me jump out a window, and then it combines it into a new use for a flying device is to escape a boring academic lecture. That can be an idea. So it made a new beverage container, and it made a flashing light. And we filed for these, and in almost every jurisdiction, but not every jurisdiction, there's a law that says a natural person has to be an inventor, and an inventor generally has first rights to a patent application. And these laws date back decades to times when people were concerned about companies owning patents, which they own most patents, and not listing human inventors, so human inventors wouldn't be acknowledged, it would violate their moral rights. And so a person has to be an inventor, even though a company usually owns it. And there's really no law in any jurisdiction talking about whether you can protect something that has no human inventor, who would be listed if you don't have a traditional human inventor, or who would own that thing.
Does Korea not speak on that?
We'll come to Korea. Okay. So we filed these applications and say that, well, there's a lot of reasons we have patents, but the primary economic one of the US-UK regime is that we want to incentivize innovation. And people have said, well, machines don't care about patents, but people or companies like IBM and Google that are investing in inventive AI do care about patents. The people who build, use, and train AI care about patents. And so really what we want to incentivize is people to build inventive AI, and this will get us more innovation in the long run. Also, in 20 years from now, if machines are better than people at innovating, at least in certain areas, if only people could get patents but machines couldn't, you'd have a real perverse incentive where you couldn't use a machine to invent something, even if it was better, if you really cared about patent protection. So we think these things should get patent protection. We think a machine should be listed as the inventor when it has functioned as an inventor, because even though machines don't care about being acknowledged, if I could take credit for having Watson invent 1,000 things for me, that cheapens the act of human invention. So it would allow a real human inventor and someone who just asked a machine to solve a problem to have the same acknowledgement.
No, this really plays to a lot of the anti-AI, general AI thing. Once you start getting an AI that can start improving itself, like if you would be able to patent that, you'd get basically a very undesirable ethical outcome where...
What would that be?
They mean to catch up.
Well, right, so we'll come to that next, right? And then who would own these patents? The owners of the AI should own its patents. So we're filing these on behalf of the AI's owner, with the AI listed as the inventor and...
The AI.
The AI. All right, well, let's come to that. We got to go back to it. Let's go back to that. All right, so here's one. So, right now, inventive AI is kind of a novelty, or some even big companies tell me it's happening, but kind of as a sideshow or like occasionally. But AI is getting a lot better, and people aren't. So maybe in...
Reinforcement learning is all inventive.
Well,
reinforcement learning, where based upon certain punishment and reward inputs, the system is automatically finding ways to do certain things, right?
Yeah.
That is exactly what you're talking about.
Right. Well, there's a lot of different AI architectures that can generate new information. Genetic programming, neural networks, even some symbolic and logic and expert systems seem to have done this. But in any case, if in 20 years from now, you can go to Watson in the life sciences, or Pfizer can license Watson and say, what antigens should I be looking at? What antibodies will target these? Tell me how these will behave in clinical trials. And really, you just have people asking machines for answers. Indeed, it would get harder for people to compete. And indeed, the standard we use in patent law of the person having ordinary skill in the art, which we use to evaluate whether something is obvious or not, is going to change as people are increasingly augmented by AI, making them more knowledgeable and sophisticated. And eventually, as inventive AI becomes the standard means of inventing, the person of reasonable skill would really be an inventive AI, which would make it very hard for people to compete with these things. On the other hand, if what we care about is generating innovation primarily, and inventive AI is one day the best way to do that, then maybe Watson and DeepMind will cure cancer, And maybe they will have a 20-year monopoly on that and all sorts of anti-competitive problems.
Why do we need to give them a 20-year monopoly? I see why we want to give a human being a 20-year monopoly, right? Why does the AI need a 20-year monopoly?
Most are clearly very different.
Well, I don't know if I agree with that. So if, indeed, as companies or the people investing in this and hiring researchers and owning most patents anyway, right? It's a choice for IBM or Pfizer to say, do I have to ask a human research team what's a new use of Viagra, or can I just ask Watson, right? And ultimately for them, investment upstream in the inventive AI is what we want to subsidize to get this sort of innovation.
So that's right at some level, but it seems to me it becomes less and less right as the AI improves itself.
As the AI improves itself, it will naturally raise the bar to inventive activity because it will have raised the standard level of the average researcher. And it will be harder and harder to get patents, even for inventive AI.
You're making an assumption here that it raises the level of the average researcher. That's not necessarily the case. If not, the average researcher has access to the same tool. So here's the point, like it won't be averaging out.
The mean may increase, but the median
Yes.
won't, actually.
Well, it is certainly going to be fact dependent depending on the area that you're in. But I mean, that is a world we're thinking about where inventive AI is outperforming people. Right?
But I mean, the point is also the distribution of the AI. And this goes back to a question you raised earlier, right, about sort of why is we aren't seeing disruptions of the Googles of the world, right? And if in fact these are self-reinforcing, right, then you might be in a situation in which the patent system actually contributes to that self-reinforcing because only the kind of top level AIs are producing things, including improvements in themselves, that can be patented. No one else who's trying to play catch up gets patent protection because they're below the standard of ordinary scale.
And so to the extent that what you're really concerned about is an anti-competitive sort of environment, it seems to me that we do have tools for that, although as you point out, they're really not used at all. But yes, it would seem to exacerbate this concern we have about market consolidation. Although it is not necessarily going to be the case that there will only be 2 super powerful AIs in the world. I mean, there are lots of other people working on AI. The AI that invented these things we're filing on was from a small company out in middle America. So it is not just DeepMind and Watson making things. And if it does turn out to just be DeepMind and Watson, there are things we could do about that.
So we had a question over.
The fundamental point as to whether actually patent law should be completely revised in light of kind of.
Right. Of course, if you're starting from the position that really we don't need patents at all to start with, and they do more harm than good, and we shouldn't have them in the first place.
Well,
but you don't have to start from that.
But even does that argument start to increase in weight as these things kind of do start to occur, where outputs of AI.
Right. I mean, the economic theory of patents has to be, right, that we won't get innovation without it. And so the story for justification of this has to be, I think, we won't get upfront initial investment by the IBMs and Googles of the world that produces an AI that's good enough to then start improving itself to the point where we don't actually need that investment anymore.
Right, and I want to challenge that slightly because I think that the economics of patent law are that we want to accelerate innovation that would probably be happening anyway, right? And so eventually, if you have an infinite time course, people will invent everything there is to invent, and there are other reasons to invent. But providing an additional financial impetus to do so accelerates investment. And really quickly before. And what it's good you're excited. And what we really want to accelerate is development of super intelligent AI that is going to solve all our problems like climate change and the president and things like that. And if we can encourage that now through the IP system, we'll have a lot of social benefits. Sorry.
Let's make it very explicit. Like, what would happen if generative adversarial, struggling with the GANs, like if that would have been a patented invention, do you think that would actually?
Well, GANs may have
actually reduced innovation.
Well, GANs may have been a patented thing before they were called GANs, but that's a whole separate thing. But patenting an AI is different than patenting the output of an AI, sure. Right? And so. Your question is kind of what we were talking about earlier. Can you patent an AI? Do you have to deposit an inventive AI? And this is, that'd be like saying we're going to patent our researcher person. Everything,
There's actually another point, though, is that you can patent things and people can choose not to enforce them, right? For differing incentives. I mean, there's plenty of things out there in the world that are sitting as unenforced patents, and people continue to file on things without any intention of blocking other people from copying that exact infringement.
I actually think a truly fascinating question under Ryan's universe is, what do we do with open source AIs? Right. Well, no, but again, not the question of am I patenting the AI. What is who, if anyone, should own the output of an open source AI?
I mean, you have obvious, right? Like, if it's out there and everyone can do it, you're not going to meet any novelty test.
Your everything is obvious. Anyone could use this AI.
I mean, it's going to depend on the facts. Like, if the invented, like, if the concept is what you are giving to this, the question you are asking this open source AI, I mean, I think there's still, that person could plausibly be the inventor.
Okay, so we've been waiting patiently. Sorry.
No, so again, back to this creativity and the question whether the copyright owner is the AI over the output. I've come across recently about on a European product, an algorithm called Amint by an Italian group that basically helps professional musicians by feeding the algorithm with their own music, and it helps them then to create. So in a sense, and I think that's what I hear from musicians. In reality, AI doesn't really come up with terribly exciting new stuff. If musicians use it, it's usually either for marketing reasons, that they can say there's AI in it because it's the new thing, or in order, as an augmented tool, in order to advance and to kind of quicken and fasten their own creative processes. So if you have an algorithm like that for a professional musician, that just helps, comes up with suggestions of new melodies and so on.
Yeah, and
who owns the
so there's a line. There's a kind of spectrum here. So on the one end of the spectrum, right, let's put Microsoft Word. Right? There's no question that Microsoft Word helps me write things. It helps me write them more efficiently than it used to be. It's also, I think, no question that we would say it's not, right? It is not an AI creator of the thing, right? The sort of creativity is in the human input, which is being augmented, right? And then on the other end of the spectrum, I would put we fed all the Franz Kafka novels into a Kafka novel generator, and the Kafka novel generator generates novels that are like Franz Kafka, and let's assume are good, right? So, or at least sort of interesting enough that they might be purchased. And there, I think in that latter case, right, there's a parallel argument to the one Ryan's making, which says just as he thinks the AI itself should be an inventor, the AI itself should be the author, right? That the AI has generated something, and yes, it's true that it generated it from a base set of knowledge, but that's kind of like a training data set, right? It's not, so I think your case is in between the two, and realistically that's where we are and probably will be for most types of things for a little while, although there are examples of painting AIs, right, which have generated sort of and sold paintings sort of in the style of kind of Dutch masters, for instance. Now, Dutch masters was not an accidental choice. Copyrights last a long time, but they do eventually expire. So as long as your training data set has only things from before 1924, you're in good shape. But of course, that's not really what popular music or most other things will want to be trained on. So I think on this copyright question, the laws might actually turn out to be somewhat different. Maybe not.
I want to talk about the chimpanzee.
Yes, exactly. So that we do have a case that presents this question, not quite for AI. This is the monkey selfie. So you might or might not have heard of the monkey selfie, but about 4 or 5 years ago, a photographer went down to a tribe of monkeys and sort of set his camera down, and one of the monkeys picked up a camera and took a very iconic selfie photograph of it. And this photograph became very popular, very well known, and the question was, who owned it, if anyone? That question was decided by the Ninth Circuit Court of Appeals here in California last year. The People for the Ethical Treatment of Animals intervened on behalf of the monkey, saying the monkey is the copyright owner. The monkey is the one who took the photograph. And so the monkey has created the creativity. The owner of the camera says, no, I am the copyright owner because it's my camera and there's a photograph that came out of the camera. The Ninth Circuit said, last year in this case that monkey cannot own a copyright.
Well, not quite.
Well, okay. Yes, they did, but all right.
No. They
Say
did
the
not.
monkey didn't have
They
standing.
kicked the case on standing. They said Congress did not authorize a monkey to sue under the Copyright Act, so we are not going to entertain this case.
Correct.
And the Copyright Office, there is no case on this. The Copyright Office has a human authorship requirement, which it cites to the 1889 case of Burrough Giles v. Cerrone in support of, saying that only
Earliest photography case.
only the acts of human intellectual creativity can be protected, and that was a case where the defendant was saying because he used a camera, it negates human authorship. This is just a recreation of a natural phenomenon. But there's never really been substantive consideration of the policy behind non-human authorship.
So right. So I mean, to be fair, right? It's not obvious to me that it makes sense to say the monkey can't have a copyright. But the one thing I think that does seem right to me is that the owner of the camera shouldn't have the copyright.
Well,
and so this I think has an interesting kind of parallel to what Ryan's talking about, right? Because so his claim is I own the camera. The camera, through some non-human agency, generated creativity. It created this photograph, therefore I should own this output. That seems to me kind of parallel to the argument that you're making for patents in AI.
So I think that it is a very parallel case, but not here. The camera is just a tool, right? The way almost every computer is a tool. The inventions we filed on, and some leading AI systems, are functionally mimicking human creative behavior, right? And a camera.
But so was the monkey.
Well, first, the David Slater, who was the photographer in that case, by the way, like the Napoleon v. Cerrone case, claimed later maybe that he set the whole thing up very carefully and enticed the monkey to come over.
Not what he claimed when a picture was first taken, but by the time of litigation, that is in fact what he claimed.
And I should be clear in our patent case and in my scholarship, I'm not saying the AI would own the patents. That's just crazy. Because in addition to legally being unable to, not having legal personhood, they have no interests or moral agency. They wouldn't be incentivized by patents. It's really the behavior of the people who make, sell, and use AI. And for the same reason as copywritten work. So AI's been able to write books or take photographs or make paintings for a long time. They're just starting to have real financial value. And again, in 20 years, AI may be doing a better job of making boy bands than actual boy bands themselves. In which case, this isn't going to be like a funny monkey novelty. It's going to be like, wow, our society is changing.
We're halfway there with K-pop anyway, right?
But can you go further on how, in your view, it's not a tool? How it's qualitatively different than
and so it's even, I think that's a little trickier in copyright, where the bar to not being a tool for a person is so very low. That wasn't quite how I meant to say it, but I think it works, right? I mean, with human invention, we have a test. Did you conceive of or devise an invention, right? And I can give you a factual scenario, hypothetically or not, where there's no person who qualifies there and the act was done by a machine. So if you have a machine that is, training on every picture on the internet, and then you push a button and say, give me a new picture, and it makes a picture that for no one is confusingly similar to another picture, right? I'd say the machine there functionally made something creative. If you are just pushing a button and a camera is capturing light and imprinting it digitally or otherwise, I think that's a tool. Even though the bar for originality and creativity is so low in copyright, there is still a bar for that, right? So, I mean, I guess if you drop your own camera and it takes a picture, that doesn't make anyone an author of that picture. It hasn't come up in a case yet.
It's unclear. I mean, there's kind of stray language that suggests it might. But to me, where this goes in both of these contexts is, it doesn't seem obvious to me that anyone should own the photo in the monkey selfie case. Right? That is, if the point of copyright law is to encourage creativity, and creativity requires that sort of human agency to be encouraged, it's not. The monkey doesn't need the incentive, and the guy who owns the camera didn't do anything that sort of involves the incentive.
So it can be that nobody owns it, right?
It can be.
That's an option.
Exactly.
And so that's the Copyright Office policy. The UK, incidentally, has a different rule that says, in the case of a computer-generated work, the producer of the work is deemed the author and owns the work. And I think that you should have copyright for animal art, and I think that the owner of the monkey should own its copyright, which would be the Indonesian Nature Reserve. And even though, so this is a novelty, there's not a huge market for animal art, but there is a market for animal art. And if people buy paintings by gorillas and elephants, if you allowed copyright on this, you would incentivize that. You would have, zoos and nature reserves finding a new potential source of revenue. It's a small thing. The AI is like that, but a big thing, right? Where
But you're saying UK, so the UK works like that across every principle though, right? Like any employee who creates something, their employer basically owns that under UK IP regimes, right? So
well, under the default one generally, but the
Yeah.
US has a similar
Well-
sort of regime like that.
Sir, all right, sir.
not about patents.
Well-
on this actually rather, so it's not hypothetical. What we're looking at in terms of biodiversity, we're looking at AIs to look at biomimicry, so the behavior of certain species and how that can be used, because that's got value to different robotics, and can there be revenue streams back to the countries of provenance? It's something called the Neukom protocol. And so in that case, you just mentioned on the chimpanzee case that the IP would not revert, there cannot be a human inventor. So in our application of, nature's behaving in a certain way, swarms of species or individuals, there is an AI which is improving, that's identifying those bodies, creating an algorithm. That algorithm is then sold on to robotics companies who need them for various reasons, or traffic flow and other areas. In that case, who would own that IP? Or you say that there is no protection really for this sort of application?
Well, I think probably under current legal regimes there would be no protection, and the U.S. isn't part of the Nagoya Protocol. But that is a very interesting intersection of how computer-generated works and genetic resources and biodiversity have kind of this interaction like that, or maybe data harvesting from companies and using AI to train it. I mean, those are kind of cutting-edge, unclear questions to me, but I don't think they'd have a case under current U.S. laws.
Well, if I understand what you're describing, which maybe I don't, you're describing a algorithm that is inspired by what animal.
Correct. Imitate or inspired.
Right. I mean, that seems the creators of the algorithm would own any patents that are related to that.
I think he was asking if it was inspired by a nation's kind of biological diversity, would they have some claim on the IP that
But
comes
it's inspired
out?
by there's lots of mechanical things that have been inspired by trying to mimic various things about the real world that the creator of that mechanical thing owns.
And
Right, so
not just mechanical things, right? Lots of pharmaceuticals, right? And so there's, I think we've both, at least in the U.S., right, we've distinguished between you are the inventor of this new drug, right, Taxol, that you got from the bark of the Pacific yew tree, even though it came out of nature because you've changed it and modified it in ways that are valuable, or you made a synthetic equivalent.
You don't get the actual, that's an important
You don't get the bark of the Pacific yew tree, but I think you can get.
You can get the method of making a bark.
You can get method of making. You can get a synthetic. I think you can also get stuff taken and isolated and put in pill form. Although that is.
That's a method of treatment.
Well, no, the pill itself.
Isolated.
Now that is, but that is less clear now than it used to be under the law. But then I think there's a second level question about sort of whether or not we want sort of regimes or rules to give back to the countries in which these things were found, right? And that's, I would call that a sort of quasi-IP regime, right? Because it's not, intellectual property doesn't actually do it, but we've got sort of various efforts, right? And the Nagoya Protocol is an example here of efforts to try to kind of make sure that if we got the basis of this valuable invention out of the rainforest, out of nature somewhere, or out of a culture, right, that we give back some rights to that. But I think it doesn't fit well with kind of the way we structured existing IP law, but we sort of layer it on top of it.
So would it be the algorithm, it's something within another body?
I think you could patent the algorithm, and you would own that algorithm free and clear, despite the fact that you were inspired by the animals. But then you might sort of feel either some moral or maybe kind of legal obligation, depending on where you are, to say, hey, we should compensate kind of or give back to the society from which we got this inspiration.
A question behind you.
Yeah.
No, you go ahead, you go first.
Yeah, so Ryan, you are essentially arguing that there needs to be some agency, or it came up that there should be some agency behind an inventive act.
No. That was in terms of ownership of property. I think having AI owning property right now, both legally doesn't fly, but also wouldn't happen. There are good reasons for that, including the fact that AI is property. It doesn't have any moral interests. It would wreak havoc on our legal systems without a very good kind of narrow case for it,
Right. So artists often talk about kind of human intentionality as a basic principle of art. And and even animals can have intentionality, like the monkey case, but how would you argue that an AI system operating completely autonomously has some intentionality or has some agency that drove the creative act in the first place?
And I would,
and is it necessary or not?
I would tend to say throughout all of this that intentionality and awareness of one's activities are not really necessary for regulation of AI, right? It should be based on what an AI is functionally doing, not whether an AI can think in a philosophical sense. And so if an AI can autonomously generate a useful idea that's the foundation of a patent, it really shouldn't matter to us whether it's like thinking about what it's doing or just combining things in a way that makes useful stuff.
So if there was a human that set up the problem that said, let me have the AI system try to figure out a new invention in the area of whatever, flashing lights.
Right.
So is the setup of the problem a contribution to the invention or not?
Sometimes. It depends how specific the problem is. So in some fields, figuring out the problem is really the inventive act, right? Formulating the problem precisely. If you say build a better aircraft wing or make a better battery or find a new use of this drug, right? That I do not think qualifies someone to be a patent inventor. But if you say, I need to find a new use for this in this particular indication, I have some idea it's going to work here, I think we need to look at these data sources and I think we need to exclude this sort of outlying data and then plug it into the algorithm and see if it works. I think that makes a person an inventor. And I think really the analogy is we have people that can help reduce things to practice as like laboratory assistants or Microsoft Word or tools. So if the AI was a person, would what it is doing qualify it to be an inventor, is I think the right way to frame it.
Just a question for Bob. I kind of really like what you're doing, Ryan, in trying to kind of bring some cases to get some jurisprudence out there. Like, what do you all think would be interesting if you could make up a case or kind of find one that would really help kind of resolve some kind of outstanding kind of challenges around this domain?
You know, it's been my experience that you can't make up cases as crazy as the ones we get in the real world. But well, right, exactly, right, yeah, right. Sort of like, I would never have thought to sort of come up with that as a copyright exam hypothetical, right? That sort of monkey takes a selfie, right? I mean, look, I think a lot really depends on the sort of ways in which the technology develops in ways that I just don't fully understand yet, right? So I think the legal system looks very different in a world in which what we've got is really big data and we just kind of test a bunch of hypotheses and do a bunch of statistics, and because we have more data and we're faster at it, we get better outcome than we used to. And then with that, I tend to lean toward Lisa's view of the patent system's got this, right? We've got our own quirks, right? But we kind of know how to deal with those things. The world in which the AI actually sort of starts to self-improve in sort of truly unexpected ways, to parent what is an improvement, right? At that point, I think just is much harder, right? Because I do think it is. I think it's more difficult for us to try to judge that by existing legal standards. So maybe the answer is we judge it by existing legal standards and we just end up throwing everything out. Ryan's paper, everything is obvious because now the AIs can all figure it out. Maybe it's, we adapt the standards to try to replicate what we've done in the human world now that the AI is the creator, AI is the inventor. I'm inclined to think that if we're in that world, right, and the AIs are sort of kind of generating new stuff because they're sort of running, we started them doing something, but now they're kind of running themselves and they're doing what they want. The idea that we need to kind of try to map that to an existing legal system of intellectual property that wasn't designed for it seems to me wrong. I think the IP is a system that is designed to create artificial scarcity where we didn't have it, because we get scarcity. That's how our economics works, that's how our business works, that's how we know how to sell things. But it's not obvious in this world, right, with that AI, that we need to sort of tie ourselves to a scarcity model and a post-scarcity landscape in which the answer is where inventions aren't scarce and don't require sort of huge investment teams. They happen because AIs kind of were asked to solve a problem, and so they solved it. That may be a world in which intellectual property is not actually the best way to think about this, because it won't end up accelerating the development of those new things. It'll end up delaying it as we end up in legal fights over ownership. So my inclination is to kind of...
is really the same in many ways as Ryan's everything is obvious answer. That, I mean, the obviousness doctrine in patent law, a lot of people say the right way to think about it, and I think there's a lot to this, is through the question of, like, something is not obvious such that we should give a patent when you need the patent in order to induce its creation in the reasonable time compared to what would have happened without the patent. And when we move to a world where things are being created regularly without the incentive of a patent, then everything is obvious and you don't need the patent system under the patent system's own logic.
So what's curious is that copyright and patent law may go in different directions in this regard. Right, because our standard for originality and copyright is so low, right? I think we would say the Franz Kafka novel is copyrightable subject matter. And there's no obviousness test as there is in patent law. I don't know that we need to sort of be granting copyrights to people who happen to own AIs who are sort of generating Franz Kafka novels. If we do, and we think about this from the patent side too, if we do, it's not to encourage the AI. I think it's actually to sort of kind of create a welfare mechanism for artists, human artists and inventors. Right, that it's perfectly possible for me to imagine 20 years from now, not just that sort of an AI is as good at making boy bands as the boy bands are, but that all of the music that people most want to listen to is actually generated by AIs, because AIs have actually figured out what people want to listen to, and they have responded to that better than sort of individual humans can. And maybe the answer is great. We got free music of a kind that sort of pleases us more. Excellent. I feel sorry for the people who used to make a living as musicians, just as I feel sorry for the people who used to make a living as horse-drawn carriage drivers or truck drivers, and by this time, right? But too bad that's one of those businesses that's gone by the wayside. But we might actually think, you know what, actually there's value in human creativity that's not just measured by what's how much do people like it, how much are they willing to pay for it, but that's value in the act of creating, right? In the act of producing the art, right? Maybe that's constitutive of what makes people human. Maybe it's sort of contributes to the culture in a way that is independent of the output. And so then what we end up with is IP as a kind of subsidy for sort of human creativity in a world where AI could do it without the IP.
Novels and, you know what? I'll be quiet because you've been trying to get in for a while.
Sorry, we have our backs.
That's okay, 2 times. So can we circle over, Ryan, that's your name, right? I feel like the cases you mentioned as kind of pilot or test cases, literally cases, are very interesting. So I kind of want to walk out with the correct takeaway. Is the takeaway, in your mind, on those cases, a test of whether AI can be considered the human, the proxy human for innovation? Or what is the central thing those cases are testing?
Well, they're testing three things. One, whether you can get a patent on something not made in a traditional way by a person, so where you don't have a traditional human inventor. We could have a new rule for saying someone's a human inventor there, but we don't right now. Two, who would be listed as an inventor on those applications, or what? And then three, who or what would own those applications? Okay. Our position is, if it's an invention's an invention, so there's no reason why IBM shouldn't be able to patent something made by Watson as well as one of its research scientists. If a machine has functionally been an inventor, it should be listed as one, and the rights to the invention would go to the AI's owner. Okay. So we announced this a couple months ago. Patent offices have been very surprisingly to me receptive to it. Not all of them, some of them not so much.
You could say Korea if that's relevant, the answer.
Right. So in Israel, they said, you don't even have to disclose an inventor, so this really isn't an issue for us. It only comes up during a dispute. We're discussing it with some other. The USPTO is having a request for comments period and is interested in the case and is trying to figure out what do we want to do about
I
this.
mean, it's clearly cutting edge, so.
Right, and I think even 5 years ago this would have been viewed less favorably, but it seems to be
So relevant.
people are interested in this right now.
And then my second question was, so do you think either in law schools or with patent or copyright lawyers around the country, how many of them are thinking about the AI issues, or it's really not?
Lots.
Oh my God! The difference between now and 2 years ago is unbelievable. And so yeah, our students. This is kind of the hottest thing for our students right now. There are the Stanford AI and Law Society, which the students founded 2 years ago, as kind of 60 or 70 members in the new class, right? And the classes are springing up everywhere. People are really starting to think about it. I started teaching 25 years ago when the sort of law of the internet was a kind of new and baby thing that was sort of looked a little odd, and this feels a lot like that to me, for what it's worth, right? That there's a whole bunch of kind of really fascinating questions, right, that have both practical import, but also kind of end up kind of driving our philosophical, why do we have this, right? What is it that makes the creativity worth protecting and that kind of thing?
And in addition to we talked a lot about the intellectual property rights and the copyrights and so on, right? And is there a third front called the data rights? Who really owns the data, right?
Yeah, so we ended up kind of detouring off of this, right? So I talked about the kind of training data set from the user's perspective. Am I going to get in trouble from training, from using copyrighted material in training data? But the people who happen to have or have collected, right, sets of data or have an interest in protecting that themselves. Now, if it is their own creative material, if you took a bunch of photographs, no problem, copyright law will protect those individual bits. But usually it is either stuff you don't yourself own the underlying copyright to, or it's facts, it's information about the world, which is not copyrightable. So the question is there some right in the aggregate whole of the data set, even though I don't have rights in any of the individual parts to own it.
Things like clickstream, right, or the search keywords I'm putting in, where does it fit, right? It is not an image, it is something that I am creating and putting in like millions.
Okay, well, so that's a different question. So I'm envisioning sort of, you go and search the Google database. Google would like to be able to say, we have ownership rights over our database, our universe of things, and so we can control what you do with it. In Europe, there is a database directive. So there is at least limited protection that gives control to people who have built and compiled databases. In the US, we have traditionally said no protection for the database, for the individual facts in the database, but you can protect the selection or arrangement of the data. Now,
this is for published information.
Yeah, for under copyright law, right? Yes, trade secret is another, right? Trade. Yeah, good point. We will come back to trade secret, right? So, but published or not, it is copyright law will protect the selection, if a creative selection or arrangement of a data set. So, if I wrote the sort of my 100 favorite restaurants in the Bay Area. Even though there are individual facts, my selection of which ones go in the 100 is idiosyncratic and creative, and I get to protect that against someone who copies it. The problem is, right, arrangement has essentially gone by the wayside as databases have become computerized, right? We used to think about how is this organized. So if I rank them from best restaurant to 100th best restaurant, I might protect that creative arrangement. Databases are not really arranging things in a creative way. They're arranging things in a functionally driven way. And selection, for some databases, that will matter. So if you've curated the best photos of stop signs or the best indicators of kind of exemplars of voice for each different accent, that could get you protection. But if what I want is a training data set that is as big as possible, has all of the things I can collect that might be relevant to this, just gathering everything is not itself creative. So I think we will ultimately see a kind of push to get some sort of legal protection for the training data set itself, at least against wholesale copying, at least against somebody who comes in and just sort of scrapes the whole thing. So we might see that in Congress. We might see it through trade secret law or through some effort to use contract.
It's
or
there now.
if it is a secret.
Do you want to talk about the other leg though? Because I think the answer to your question is your inputs into, let's say, the search engine or Amazon, right? By contract, you've given up in your interaction. They are deemed the owners of your interaction.
Right, and there are proposals,
proposals
out there to create sort of property-like rights in your individual personal data. Right, to say, well, my data in the Facebook graph, right, or my sort of clickstream choices are things that I should own. I don't know that those are going to go anywhere. I kind of hope they don't go anywhere, because while I think there's a real benefit to greater privacy protection, propertizing each individual's privacy data strikes me as a bad way to do it, in part because now you've got 500 million people.
Talking about rights clearance.
Yes, exactly. And the only way we will clear, we either won't use any products that use the data, or we'll clear it in this kind of, by coming on my webpage ever, you have agreed to the following terms and conditions, which I will change at my convenience whenever I want, which is kind of how we do it now.
Yeah.
What about derivative data on that stuff? Like, for instance, for machine learning, often isn't actually the video it's important, it's actually the data you derive from it, such as distance between people, or so it's actually the machine learning algorithm is actually trained on the derivative of the actual copyrighted, potentially copyrighted.
This is a great question. I have a draft paper now, right, talking about this sort of how to solve this copyrightability. Will I be in trouble for copyright for using this training data set? And what Brian Casey and I argue is that where the thing that makes this valuable to my AI is not the creative part, not the reason we are protecting it, we shouldn't treat my use of it by the AI as copyright infringement. So if all I'm interested in is the facts, all I'm interested in is the stop signs and not sort of the artistic lighting that you took of the picture, the reason we give copyright to those things just doesn't map to the reason that I'm making use of those things.
Is that the functional, non-functional?
It is, right, and the problem
that
is...
may be worth explaining.
That's right.
Exception to the whole...
Right, yeah, so copyright law protects the creative aspects of things, but not either the underlying idea or the functional elements of things. And that can look a little weird. So at a basic level, it means, right, I can't copy your novel, but I can write a novel that has a number of the same elements, right? It has a love triangle and a sort of murder in a locked room and whatever else.
The exception also means there's a large body of folks, which I'll say I'm in the camp, but most of software is probably not copyrightable.
Yeah, so we copyright computer source code, right? But one of the oddities is, right, in theory we are protecting only the creative and not the functional aspects of that code.
Things like front-end interface,
well,
the stuff that we actually
really
care about.
Or right, I mean we do well. It may also mean that the worse you are at writing code, the more protection you get.
Yeah.
Right. If you got from A to B by going in a straight line, that's functional. If you kind of meandered all over the place, you got a lot of exactly. Now, I mean, what we've really done is basically used that to prevent primarily exact copying of code. But there are cases, including the Oracle versus Google case going on right now, and right in which we've broadened that universe pretty broadly to effectively get some control over functional stuff. So I think I think the answer is there ought to be a way for an AI to use the unprotectable parts of a copyrighted work, and the problem is that everything involves making a copy of the whole thing to ingest it, and that's how you get in trouble. But we ought to...
Unless it's an ephemeral copy. So you can make, right, milliseconds long, right, the courts have tested, millisecond long copy. At some point in the spectrum, it's not deemed a copy, even though logically it actually is.
The law there is a bit of a mess. So in the Second Circuit, you seem to have at least a second. For which you're making a copy that only lasts for a second is transitory duration. Yep. Here in the Ninth Circuit, the courts very early on held that turning on your computer is an act of copyright infringement because you're loading data into RAM memory every time you're turning on a computer, and so you're making a copy. I think that's silly, but it's out there.
We have a new question in the back.
Yeah.
just kind of a wild card question about, to the extent there is a copyright in the database, and apart from the trade secrets issue, and an entity such as the Google controls a large database and won't license it, could there ever be a scenario where a government could impose eminent domain on that for the public good?
Yeah, although the problem, right, I mean, the problem is if you impose eminent domain, you got to pay for it, right? So, right.
Unless it's by dole. Unless the government is funded.
On the patent side, right. Yeah, but we don't have a copyright equivalent of Bayh-Dole, that's right. And so I will say, right, in the trade secret context, right, Jim mentioned earlier the sort of FDA and other things. When we cited food and insecticides and various other chemicals had to list all of the ingredient labels, we took a bunch of people's trade secrets from them, right?
Yeah.
And we had to pay for it.
Well, it depends on how much, right? In a lot of those things, just the courts held that the requiring to list your ingredients did not reveal the whole process and formula. And if you were to take the whole process and formula, that would be a taking. But there is this this line between regulation and taking, and just listing ingredients, if it doesn't reveal how to make it, doesn't pass the essence of the secret, then the government hasn't taken it.
So the food it hasn't taken it. For insecticides, where we actually had to give the percentages, the court Monsanto versus Ruckelshaus says it is a taking, right? So
yeah, well, there they gave it up. What had been filed got released.
Right.
So the property, such as it was gone through that. And so, yes, eminent domain would apply. I mean, trade secrets are treated as property. So it could be done, but there's a very important health and safety regulatory framework to all of this, right? I mean, because you can't say, if you have hazardous chemicals, right, the fire department will not have to pay you to make you tell them what you have.
Right. But I'm just thinking the use of a data set for machine learning purposes for a social benefit, right?
Yeah.
I think there's going to be substantial pressure, I mean, whether it takes the form of eminent domain or not, I think there's going to be substantial pressure in a number of fronts, right, to make sure that, if this is actually determining how safe your car is, right, we want not only Google to have access to that data, right, not only Company X. If it's medical, surgery or medical diagnostics, if it's criminal sentencing, but probably that will sort of spread to a bunch of other things, right? Bank loans, maybe not weather prediction, although I can see the argument for that, right? But I think a number of kind of databases that are integral to sort of AI that has some public safety or health effect, or some kind of fundamental life activity effect, there's going to be strong pressure to get access to that information, and that's going to push against the trade secret.
Updates over the air, they're begging for this reaction, in my opinion, right? Because it's the combination of, we just changed the software on everything on the road. You don't really know what that was or the data behind it. I'm sorry, I know you're a fan, but
but it's not. I mean,
your example, no?
Well, but it's. I mean, so Tesla actually separates the drivetrain software from the actually air gaps the drivetrain software from the sort of computer control software. But so it's not. But that said.
All the autopilot stuff.
No, you're right.
The battery charging.
I think that's right. And so, I mean, there's also the question of in what form is that information useful, right? So it's not obvious that sort of just that information is valuable to anyone other than who doesn't already have a kind of Tesla algorithm. And this goes back to some combination of the explainability and what do I get, right? Is a deposit actually helpful? All right, so we are out of time. Thank you guys. I walked in here thinking I'm not sure we have 2 hours to fill, but you guys helped us fill it, so thank you.